Zumo. I'm the president of the Long Island Lawyers Chapter. Stand up.
Just watch the light fixture when you do it.
I don't think I need to stand. I think I have a loud enough voice, and most people don't. Okay, I'm Michael Zumo. I'm the president of the Long Island Lawyers Chapter of the Federalist Society for Law and Public Policy Studies. And I want to welcome everyone who made it to this sort of well-attended event. I don't know.
Very well attended.
Very.
Very well attended.
You know, we hold it in a small room to make it look good.
And you want to keep the dance floor clear too.
That's it. Actually, there may be some dancing going on later. It depends. If the bar stays open during the debate, some people may need to have a little
I thought he meant dancing around the issue.
libation. Okay. The Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. The Society seeks both to promote an awareness of these principles and to further their application through its activities. Now, we're very fortunate today to have a great panel discussion on an issue that has sort of been burning in the public consciousness for the last couple of years, the Patient Protection and Affordable Care Act, which is sometimes euphemistically referred to as Obamacare. Now, what we're going to do is I'm going to introduce our moderator, Judge Bruce Cousins, and he will introduce our panel members, and then we will, each panel member, and I don't know if you guys want to flip a coin to see who goes first, but each panel...
We already flipped the coin.
You already flipped the coin.
It wasn't on camera. But
Okay, all right. So what will happen is, each person will give a 15-minute presentation. Judge Cousins will keep a very tight watch on the time, and then they will each have a 5-minute rebuttal period, and after that they will take questions and answers from the audience. Okay, does that sound good to everybody? So let me just introduce our moderator. Our Bruce Cousins has served as a justice of the New York State Supreme Court since 1998. He was first elected to the Supreme Court for the 10th Judicial District, which is Nassau and Suffolk counties, in 1997. He was just re-elected last year to a 14-year term. And Justice Cousins is currently, he's still the presiding justice of the Trial Assignment Part of the Supreme Court, Nassau County. In the Trial Assignment Part, he oversees the trial judge assignments for all jury and non-jury trials. Prior to taking the bench, he was an attorney in private practice and a founding partner of a Long Island civil litigation firm, McCabe and Cousins. And of course, Steve McCabe, I know, is here somewhere, his former partner.
Hiding in the back.
He's hiding in the back. Well, it's better than hiding in, well, we will talk about that. Let's see. Okay. Justice Cousins is also an adjunct professor at the Hofstra University School of Law, where he teaches a practical skills course called Pretrial Skills, in which the students learn to apply their knowledge of the law to the practical, day-to-day work of a litigation lawyer. He is also a regular instructor in continuing legal education with the Nassau County and New York State Bar Associations and the National Business Institute. While in private practice, he was chairman of the Insurance Law and Municipal Law Committees of the Nassau County Bar Association. Justice Cousins holds a BA degree from the University of Virginia and is a graduate of Pace University School of Law. He's a member of the Nassau County Bar Association, the Nassau County Women's Bar Association, and this is a new one on me, the Lawyer Pilots Bar Association. And probably his greatest claim to fame is he's one of the founding members of this chapter of the Federalist Society. Without further ado, I would say that.
Thank you. You kind of took some of my thunder away in describing the procedure, so I guess I will preside impartially. But let me just go into, Ms. Mazier is going to start off with our first presentation, so as introductions of our panel here, let me start with Professor Friedman. Leon Friedman is the Joseph Kushner Distinguished Professor of Civil Liberties Law at the, I had to add this in, it's now the Morris A. Dean Law School at Hofstra University. And I believe we were discussing earlier, he's been there for 38 years, so obviously, I know we have some Hofstra students here. If you haven't taken his course, it's a good course to take. You take one of his courses.
It's a waiting list.
Waiting list? Well, get on the waiting list then. He also teaches in the area of constitutional law and copyright, as well as employment discrimination and civil rights. He's also a practicing lawyer, where he specializes in First Amendment law. The professor is the graduate of both Harvard College and the Harvard School of Law. And he served for a time as a staff attorney for the American Civil Liberties Union. Professor Friedman has written or worked on briefs for the United States Supreme Court on many important cases dealing with the First Amendment, copyright, as well as civil rights, employment discrimination, civil procedure, and abuse of government power. He has represented a number of publishers, including Farrar, Straus and Giroux, Arcade Publishers, Chelsea House Publishers, as well as many authors, including I.B. Singer, Susan Sontag, John McPhee, Stephen Spender, Hunter Thompson, as well as the estate of Edith Wharton and T.S. Eliot. He is a general counsel for Penn American Center and is a former member of the board of directors of the New York Civil Liberties Union. He's published numerous books and articles on legal subjects, including Brown versus Board of Education, The Complete Oral Arguments, the Civil Rights Act of 1991, the Supreme Court Confronts Abortion, Law of War, The Wise Minority, The Justices of the Supreme Court, 1789-1969, which received the Scribes Award as the outstanding book on a legal subject during 1970. He's also written about 100 law review, newspaper, and journal articles. He was also the co-author of a Broadway play entitled The Trial of Lee Harvey Oswald. So obviously, we are very privileged and lucky that Professor Friedman is with us here tonight. All right, opposing him, arguing against the constitutionality of the Patient Protection and Affordable Care Act is Deborah Messier. She is a founding member and partner of Lally and Messier. She specializes in complex civil, commercial, and appellate litigation before both the federal and state courts. She is a leading federal litigator and expert on administrative, constitutional, and government regulatory law, briefing over 70 federal appeals cases up to and including the U.S. Supreme Court, and making 17 federal appellate oral arguments. In addition, she provides advice on regulatory compliance and public policy issues. Her clients included local governments, venture capital funds, tech and energy companies, hotels and restaurants. Before entering private practice, Ms. Messier served in the administration of President George W. Bush as U.S. Deputy Assistant Secretary of Policy at the U.S. Department of Labor, Ethics Attorney at the White House Counsel's Office, and Chief of Staff of the Occupational Safety and Health Administration. She also taught appellate advocacy at George Washington University Law School. She started her career at the U.S. Department of Justice, serving in the Executive Office for Immigration Review, headquarters of the former U.S. Immigration Naturalization Service, as well as in the Justice Department's Civil Division. At the Justice Department, she was specially assigned as counsel to the U.S. Foreign Terrorist Tracking Task Force. The Counterterrorism Intelligence Task Force created in the immediate wake of 9/11 to prevent future attacks, and as counsel to the U.S. delegation to the United Nations International Maritime Organization. Ms. Messier graduated with a BA with honors in political science from the University of Chicago and an MA from the University of Chicago's Master of Arts program in Social Sciences. She earned her law degree from the University of Minnesota Law School. After law school, Ms. Messier served honorably in the U.S. Marines. I'm going to hand the stage and the floor over to Ms. Messier to begin with her argument.
Thank you very much, Justice Cousins, and good evening, ladies and gentlemen. It's a great honor to be with the Hofstra and the Long Island Lawyers chapters of the Federalist Society this evening. And we're going to debate the constitutionality of the Patient Protection and Affordable Care Act, popularly known as Obamacare. Our firm was the only Long Island firm, and I think perhaps the only New York firm to file amicus briefs in this case before both the U.S. Federal Circuit Courts of Appeal and the U.S. Supreme Court. We filed the brief on behalf of one of our clients, the Cesar Rodney Institute, which is a good government group down in Delaware, and they were opposed to Obamacare. Tonight, I'm going to briefly present the state's position on this litigation, so the states who challenged the constitutionality of Obamacare, and I believe Professor Friedman will be presenting the government's position, and then hopefully we'll have a chance to answer some questions afterwards. So just to give you a little background on the Patient Protection and Affordable Care Act, as you all know, it was introduced in September 2009, sponsored by Representative Charlie Rangel from our own home state here in New York. It passed the House 219 to 212, 34 Dems and all Republicans voting against in October 2009, and then passed the Senate 60 to 39, all GOP voting against in March of 2010. And if you may recall, it subsequent to that, Senator Scott Brown was elected in Massachusetts, and that election actually had a lot to do with the final format of the Obamacare legislation, because frankly, the legislation was not in a final format before they presented it, before they put it in its final version to be signed by the president. They had intended to pass another version, but then with the death of Senator Kennedy and the election of Senator Brown, they had to go with the version that passed before. So you see lots of loose ends in the legislation that have frankly come back to haunt the administration now in this litigation. 2010, the president signed it, and it came into law. So just to give you a rundown of what the Obamacare legislation did, so we sort of all know what we're talking about. The most important thing we all know is it required most Americans to have individual health coverage. Frankly, to purchase it, either get it from the government or purchase it from a private health company. Certain individuals were exempt from having to get that health coverage. They included folks who have an income below a certain level, illegal aliens, Native Americans, and also people who have a religious objection, a few other categories as well. So everyone other than those individuals is required to obtain health insurance coverage. I believe it's 2014 it goes into effect. The second thing the Obamacare legislation did is it created state exchanges through which individuals could purchase coverage with premium and cost sharing credits available to families and individuals who have a certain income level. The third thing it did was it required employers to pay penalties for employees who receive tax credits for health insurance through an exchange, with an exception for small employers. It also imposed new regulations on health plans in the exchanges and in the individual and small group markets. And then it created a great deal of reform to the private insurance market. The most talked about parts of that included the guaranteed issue in the individual and group markets, the guaranteed renewability, the pre-existing conditions, so an insurer can no longer deny coverage to an individual who has a pre-existing condition, and in addition, the essential health benefits package, there has to be certain things included in the products that are sold across these exchanges. And finally, what the PPACA did was it expanded Medicaid coverage to 133% of the federal poverty level. So it basically brought more people into the Medicaid program. It gave some funds to the states to cover that, but a lot of the money has to be picked up by the states themselves rather. So the way this litigation started up was there was numerous cases filed at the district court level. The most significant one for our purposes was a case in Florida, Northern District of Florida, and that case, was Florida v. HHS, and heard before Judge Vinson of the district court. He found that the act was unconstitutional and that the individual mandate was not severable from the rest of the act, so he struck down the entire thing. There were other judges at the district court level around the country who did find it constitutional and upheld it. From Judge Vinson's court, it went up to the 11th Circuit, and there the 11th Circuit, in a 2-to-1 decision, held that the individual mandate was unconstitutional, and that however, that the individual mandate was severable from the rest of the act, so they allowed the rest of the act to stand. Just want to run down real quick for you the bases of the 11th Circuit decision finding it unconstitutional, so you have a sense of what the arguments were before the Supreme Court. The 11th Circuit said it was unconstitutional for 5 main reasons. The first is they said it's unprecedented. Never before has the Commerce Clause been used to require people to purchase a private product. The second thing they said was it improperly expanded what's called the substantial effects doctrine, which is part of Commerce Clause jurisprudence, which says that if an activity has substantial effect on interstate commerce, then the federal government can regulate it. So the court said you went too far with that. Third thing it did was it said the legislation itself lacks an adequate jurisdictional element. What does that mean? It means that the statute itself does not have any language tying the requirement to purchase health insurance coverage with interstate commerce. This was actually an argument our brief focused on, so we were delighted to see it in the decision. The fourth thing was the findings in the statute were highly attenuated in terms of relating the cost shifting and the activity to be regulated. Bottom line, what they were saying was the congressional findings just didn't provide enough basis to pass this individual mandate. And then finally they said, hey, this really intrudes into areas of state concern, namely health and welfare, and Congress is careful, and they're going too far. So that was the 11th Circuit decision. There were other, of course, circuit court decisions. The 4th Circuit essentially said we're not going to hear this case under the Anti-Injunction Act, which is an act that says if a tax is an issue, it cannot be challenged until the tax has been paid. The 6th Circuit found that it was constitutional, and the DC Circuit said also that it was constitutional. Judge Kavanaugh in the DC Circuit agreed with the 4th Circuit and said there's an Anti-Injunction Act. So the 11th Circuit case, the Florida case, came before the U.S. Supreme Court, and the court granted cert on 4 issues. So they had 3 days of oral argument on these 4 issues. The first was whether the suit, whether the Obamacare, whether the suit challenging Obamacare is barred by the Anti-Injunction Act. The second was whether Congress had the power to enact the individual mandate under the Commerce Clause. The third was whether the rest of the healthcare law can stand if they find the individual mandate unconstitutional, namely the severability issue. And the fourth was whether Obamacare improperly expanded Medicaid in violation of the Constitution. So I'm just going to run through for you real quick the state's positions on those 4 issues, and then I think Professor Friedman will I'm kind of scared because I heard he's really good, but he's gonna give us the other side. Okay, so on the Anti-Injunction Act, and actually Professor Friedman has written an article which I took a look at before I came in on this one, and I agree with him 100% on it. This was an interesting issue. The government and the states had essentially the same position, which was we think the court should hear this challenge. They both agreed that the penalty for not paying for not having health insurance was not a tax. Now, why this is interesting is because the government argued it was not a tax in this context. However, when arguing on the individual mandate issue, they argued it was a tax for the purpose of sustaining its constitutionality. So it was an interesting litigation strategy. I don't particularly agree with it, but they did. And the only person who argued that it shouldn't be heard was court-appointed amicus, Robert Long, a Washington lawyer. He argued that, in fact, this is a tax, and the Anti-Injunction Act precludes the court from hearing it. I won't go into all the, I don't think I have time to go into all the minutia of why the states felt that it was not barred by the Anti-Injunction Act. But a good deal of their arguments centered on whether or not it was a jurisdictional, whether the Anti-Injunction Act is jurisdictional in nature. The states argued it was not, that it's more along the lines of a claims processing statute. And then to the big show in town, the minimum coverage. The state's argument on the minimum coverage is that, number one, you can't force people into commerce. So you've heard a lot about inactivity versus activity. What the states argued is previously the Supreme Court the Congress has always used the Commerce Clause to regulate activity. Here, you have people who've chosen not to enter into the health insurance market, who've chosen to exist without health insurance, and you can't claim to have the power to regulate them when they're merely existing. You can't force them to join the health insurance market in order to have a basis to regulate them under the Commerce Clause. The second argument of the states was that the government appears to be suggesting that it has the power under the Commerce Clause and the Necessary and Proper Clause to choose any rational means to regulate economic activity in the United States. And they said, and the states argued that, again, that's just too far a stretch under the substantial effects doctrine of Commerce Clause jurisprudence. The states argued that the government's argument that the health insurance market is unique is not a sufficient limiting principle, and that it does not really cabin Congress's power under the Commerce Clause sufficiently. That it can be, the uniqueness argument can be made about almost any industry in the country. And then finally, the states argued it is not a tax. The penalty for not having health insurance is not a tax. And the reason it's not a tax is because there were multiple versions of this legislation before Congress, before the final version passed, in which they had said it was a tax, and it did not have enough political support to pass. So Congress struck out the word tax and put in a penalty. They said that's proof enough that this is not a tax. And just real quick, I just want to highlight, I've got 2 more minutes, okay. Let me give you the rundown real quick on, just so I get them out, on the severability and the Medicaid. On severability, the state's argument was pretty simple, which is the government has said that the individual mandate is central to the Obamacare legislation. Without it, none of the other provisions make sense and or are affordable. The government has come out many times and said it was central, and that if the individual mandate is struck down, the whole thing should be struck down, as Judge Vinson did in the district court in Florida. And then finally, on the Medicaid issue, the state's argument was that the government is coercing the states into spending more money by requiring increased coverage under the Medicaid Act, and that is not proper. That the federal government is essentially hijacking the state legislative process and injecting itself into the portion of state matters. So that's just a real quick summary of the state's positions.
Okay, Professor Friedman.
I'm going to go back to basics. And during the argument before the Supreme Court, Justice Scalia said, states have unlimited power to legislate. The federal government has limited powers. I mean, this is something we learned in the 6th grade, something like that. And you sort of have to ask yourself, well, why should that be? You know, why can the federal government has to look for the specific words of the Constitution, but every state can pass any law it wants, subject to constitutional limitations. I mean, state constitution or federal constitution says you can't do this. They're certainly limited that way, but not the federal government. And, you know, it all goes back to 1789, everything goes back to 1789. And the reason we have a federal government to begin with is because Edmund Randolph got up before the Philadelphia Convention and said, we have to worry about foreign invasion. We need an army. The militia not to be dependent upon, drafts stretch the strings of government too violent to be adopted. We need a regular enlisted army, and we can't do that without money. So we need a federal government that can tax and raise an army to defend ourselves. And by the way, the year before there was Shays' Rebellion, there was insurrections within the state. We need that federal army. Now, the only problem is we had just gone through the war with England, and we didn't want a standing army. The idea that there would be a regular standing army in the United States controlled by a federal government was really, I mean, James Madison, our own James Madison, you know, had a comment, you know, a government with a standing army, what can be worse to people who have tasted the fruits of liberty? And if you look at the Constitution of the 17 enumerated powers, 6 of them relate to the Army. So there was concern at the very beginning, we must limit the federal government because the government with a standing army would be a threat to our liberty. Now, obviously it didn't work out that way, and indeed, very soon, John Marshall, Chief Justice of the United States, had 20 years later, he starts interpreting the Constitution, and you know the famous words of Marshall in McCulloch against Maryland: "Let the end be legitimate. Let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adopted to that end, and which are not prohibited, but consist with the letter and spirit of the Constitution, are constitutional." In other words, the federal government needs the power to, you know, to act, to protect the welfare of the people. And then very soon after that, the first Commerce Clause case came down, Gibbons v. Ogden. What is the Commerce Clause? It is the power to regulate, to prescribe the rule by which commerce is to be governed. This power, like all others vested in Congress, is complete in itself, may be exercised to its utmost extent, and acknowledges no limitations other than are prescribed in the Constitution. I think Justice Sotomayor actually read this whole section out during the oral argument in this case. So very soon, the idea that the federal government should be limited and narrowly construe all its powers sort of disappeared. And the whole notion about state versus federal, the argument about states' rights, it's not a very good banner to march under, because states' rights was the basis for slavery, for defending against slavery. It was the basis for attacking civil rights laws, in the 1950s and 1960s. It was the basis for protecting corporations against the federal Sherman Act, so that state power or states' rights and the idea that states should have more power than the federal government has been there to defend, I have to put it this way, vested interests. It wasn't there to really protect, the people. So should states have more power? Are state legislators smarter, less corrupt? I have to tell you, when was the last time a U.S. senator was indicted for corruption? 20 years ago, 30 years ago?
Less than that.
Abscam. 20 years ago?
Senator.
When was the last time a New York senator was found guilty of corruption? Last week? Last week? I mean, there's a whole section, stateintegrity.org, which tells you how state governments. In New York, there have been 2,400 convictions for public authority violations. in the last 25 years? I mean, not such a good idea. So that the whole notion, now how does that fit here? How does that fit here? Well, the idea that we should limit federal government, or the power of the federal government, and let the states decide these things is, history is not on the side of the states deciding it. Besides which, states have not involved themselves in health care. Massachusetts. So that the idea that the federal government shouldn't invade states' rights, this is not a very good example of that. Now, so what does all this mean? The big issue, the main issue, is the whole business of the individual mandate, that people must buy insurance. Now why was that put in there? And the reason is that there are 40% of 40 million people in the United States who don't have health care, who don't have insurance. Now some of them are very poor people who show up in emergency rooms, and the emergency room must take them. Why? Because a federal law was passed in 1986 saying you cannot turn away a person in distress because they can't afford it. So the federal government insisted on, and no one made a big complaint about that. The hospitals get federal funding, so there is a basis for it. But the idea that we can't let these people die. If someone is in distress and can't afford it, we must take care of them. Now, who pays for that? Who pays for the 40%, the 40 million, there are various figures on this, but the 40% of the people who don't have any kind of insurance, who pays for that? We do. We do because the government must pay for it. It adds $1,000 a year to the health care of every single person. That's what insurance is. We have car insurance. Why do we have, I've never had an accident. Why do I have to take car insurance? Because the whole point of it is to spread the risk around. That's what insurance is. That's what life insurance is. That's what car insurance is. You must spread the risk so that everybody pays a small amount for the people who are actually covered by that insurance. And that's the heart of this law. We have a health insurance policy, we have a health insurance system where everyone must have health insurance at some point in their life. They must. They must have some sort of health care at some point in their life. And we require the risk to be spread around as we do with all insurance. That's what insurance is all about. And therefore, you can't just look at the individual mandate as a single event. It's not like, this is the analogy that everyone uses, we're going to require people to buy broccoli, to eat. No one can force you to buy broccoli. I can assure you, the state or the federal government can force you to buy broccoli. It isn't part of an integrated system. But health insurance is part of an integrated system. There's an entire system of health care that requires, that mandates that people get treated, and that someone has to pay for it. And the way to do that, eventually the government could take it all over. And there was various arguments. There's no doubt that the government could simply become a single payer. That's what they do in England. That's what they do in Canada. They could do that. They didn't do that. They wanted to leave room for private insurance. They wanted to leave room for individual people to make their choices, to decide who they want. And so the only way to pay for the system was to require everyone to contribute. So if you look at, if you take an isolated still picture of the person being forced to pay, to buy the insurance and look only at that, it looks bad. But if you look at it as a continuous operation, the stream of commerce, which Oliver Wendell Holmes talked about many years ago, you don't look at a still picture, you look at a moving picture. You look how the entire system works. And the entire system requires that everybody contribute. Now, I want to read, if I may, from two very conservative judges. Jeffrey Sutton, was he, Sixth Circuit judge. He argued both the Garrett and the Kimmel case. Now, those are two very important Commerce Clause cases in the Supreme Court, which said that states don't have to, can't be sued for violation of the age discrimination law, and they can't be sued for violation of the Americans with Disability Act because of the 11th Amendment. He is a strong defender of states' rights. And he was appointed to the court, he's a Scalia clerk, and he was appointed to the Supreme Court by Bush. And here's what he says about this in his decision in the Sixth Circuit. The third point is the critical one. Does the Commerce Clause contain an action-inaction dichotomy that limits congressional power? No! For several reasons. First, the relevant text of the Constitution does not contain a limitation. To the extent that regulate, commerce, necessary, and proper might be words of confinement, the court has not treated them that way as long as the object of federal legislation are economic and substantially affect commerce. Jeffrey Sutton. Other very conservative judge, Lawrence Silberman from the DC Circuit. And he, very close friend of Justice Scalia, very conservative judge. What does he say? Nor do we think that state power over health and general welfare make the healthcare industry a traditional state concern. Moreover, if Congress can regulate even instances of purely local conduct that were never intended for an interstate market, whether it be Filburn raising the wheat which he fed to his cows, or Gonzalez against Reich growing marijuana in the backyard, we think Congress can also regulate instances of ostensible inactivity inside a state. The aggregate effect of that behavior, after all, is just as injurious to interstate commerce. So here's our two Federalist judges. Okay, here are two Federalist judges. And yet they read the Constitution in the same way that, they read the Constitution in this very broad way, just as John Marshall did, to say that we have to look at commerce in its broadest sense. It's the power to regulate, the power to lay the rules by which commerce is to be governed. It's complete in itself, may be exercised to its utmost extent. And here is a very serious problem facing the nation. I don't have to tell you one other statistics. In the United States, we have the 38th worst record in life expectancy. We're 45th in infant mortality. I mean, we have a terrible record in health. And the reason is that the bottom part of our country people who are not covered by insurance just don't take the necessary steps to protect themselves. So for all of these reasons, I really believe, follow these conservative judges. I hope the Supreme Court does the same thing and uphold the law.
All right, rebuttal, 5 minutes.
I'll try. It's certainly true that Commerce Clause jurisprudence, starting in Wickard in 1937 up to the 90s, was strongly in favor of expansive federal government power. Professor Friedman is absolutely right about that. However, there were two cases, Lopez and Morrison, decided, I think in the 90s and 00s, that pulled back congressional power under the Commerce Clause. And in those cases, they were a shock to the liberal legal establishment. But in those cases, the court said, number one, you have to have a jurisdictional element. You have to specifically tie the activity to be regulated to the Commerce Clause. So for example, in Lopez, that was the Gun-Free Zones Act case. There, the Congress had tried to prohibit anyone from bringing a gun in the vicinity of a school anywhere in the United States. And the court struck it down. And they said, in your legislation, you had no element tying it to interstate commerce. The Congress actually went back and amended the legislation and said, and they changed the language to say no person receiving a gun in interstate commerce or operating interstate commerce may bring it near a school. And that was found to be sustainable. Similarly, in the Morrison case, that was the Violence Against Women's Act. That act had created a private civil remedy for individuals who experienced violence. And a young woman experienced violence, tried to bring a private civil action. In that case, the court again struck down the act, saying it was too expansive, it improperly used the Commerce Clause power. One of the reasons it struck it down, in addition to the jurisdictional element issue, was because, again, it wasn't present, was they found that the findings, the congressional findings, were too attenuated. So there, the Congress had said, if a woman or any other individual experiences violence, she's going to miss work. If she misses work, it's going to have an adverse consequence at her job. Most jobs involve interstate commerce. Therefore, violence against women is an interstate commerce concern. The court said that is way too attenuated, and that's not what the Commerce Clause is about. And I would submit that the Obamacare legislation has the exact same flaws as the Lopez and the Morrison cases. In the Obamacare case, there is no jurisdictional element. It says that every American has to purchase health insurance. The only exceptions are not individuals who are not participating in interstate commerce. They are people with incomes below a certain amount, illegal aliens, Native Americans, what have you. So otherwise, everyone is required to get it. It is not individuals who are seeking health care, for example, in interstate commerce. It is not individuals who are operating in interstate commerce. It is everyone, for the mere act of existing and breathing in the United States, who has to have health care. So there is no jurisdictional element in Obamacare. Number two, the findings are incredibly attenuated. And with all due respect to the professor, with the reasoning given in the Obamacare findings, which include if a person gets sick all the time, it will affect interstate commerce because they're less likely to be economically productive. You could use that rationale to force someone to buy broccoli or purchase a gym membership, because you could simply say, if someone doesn't eat well, exercise right, they're going to be less productive at their job is necessarily in interstate commerce, ergo, it's a federal government concern. So for those reasons, I think the court has a sound basis to strike it down. I do agree with some of the arguments that have been put out about action and activity. It's I think not a helpful distinction. What I think is helpful is understanding that the federal government's power is enumerated to protect the individual. So yes, sometimes states' rights have been used to, for example, impede the civil rights legislation or what have you. But what we're looking at here is the federal government dictating to Americans how they should spend a portion of their household income. They're telling Mike that he has to spend $5,000 a year purchasing health insurance when he may not want to because he's a young, healthy guy. And what we have going here, is an effort to really stop the federal government from intruding into people's daily lives. I'll just close by saying that the insurance company is the most establishment interest you would ever find. And this legislation benefits them. They are exempt from the anti-monopoly provisions of the federal antitrust laws. And in the common law tradition, in Old England, in the colonies, in America, we have a strong tradition of saying the government cannot force people to purchase products from a monopoly, and that monopolies are against public policy and bad for democracy. And what we have here in Obamacare is the government saying you will purchase this particular product from a state-sanctioned monopoly. So if that doesn't strike at the very heart of freedom, I'm not sure what does.
Professor, please respond.
Let me say something about Lopez and Morrison. In Lopez, what the Supreme Court said, it has to be a commercial activity. Now, carrying a gun is not a commercial activity. You need exact words are, must have a substantial effect on a commercial activity. In Morrison, the law focused on beating up a woman. Now, that's not a commercial activity. So that in both cases, they didn't say, what they said was, they applied the Lopez rule, it can only affect a commercial activity. Now, is healthcare a commercial activity? I think so. I mean, that's the whole point of it, is that you must pay for this, for the services. Now, it's a little hard to argue that Lopez and Morrison necessarily carry over here. It's really the distinction between a non-commercial, beating up a woman, carrying a gun, and is healthcare a commercial activity? It's the biggest commercial activity in our economy. 15% of the gross national product goes for healthcare. It keeps going up all the time. And this is an effort, I mean, Obamacare is an effort to stop it from going up and to make sure that the price of it is carried around. That's what insurance is. Every insurance that we have is evening out so that people must contribute towards care of others. I mean, it's not a monopoly. I mean, the whole point of it is to avoid having the government run it directly. So somehow we're converting a system where the government would actually run the program into something where everybody has a choice. That's what these state-sanctioned organizations are going to do. They give you choices. What kind of a health care program do you have? And that's the whole point of the law. And the point of the law, it's an integrated system. That's what health care is. It's a very difficult integrated system that is the strongest possible drain on our economy, and something has to be done about it. And the something in this case is an effort to even out the burden. And you know, I'm sure we both read the oral arguments. If they can do this, can they require you to eat broccoli? Can they require you to buy a car? Can they require you to pay for burial? Well, the one thing about healthcare is everybody does it. It's a system that everyone joins in. Not everyone eats broccoli. No one has to eat broccoli. No one has a car. But healthcare, everybody does it. You have to even out the burden, give people a lot of choices. The law should be upheld.
All right, very good. I'm sure there are a bunch of questions here, so we'll start right there.
You'll forgive me, sir, I'm not a lawyer, so if from a legal perspective anything I might say is ignorant, excuse that. But your first point about how, within 20 years we didn't really have a limited government anymore, and that was your argument. If there's no limitation on government, and if this is not an intrusion, where is the limit? And if there is to be no limit, why not just rip up the Constitution? Because Congress and the federal government can do anything they want. I'll just go to all three, and then you can take them in any order you want. Secondly, you made the point about the hospitals, that people will walk into an emergency room and get cared for. You'll excuse me, but I think that's a question of big government stepping in and saying, okay, you must take care of this. Oh, and by the way, now we created a problem, so now we need even more bigger government. I think that truthfully, if somebody walks into an emergency room with an axe sticking out of their forehead, I think we would all pretty much want them to be taken care of. But if they've got the sniffles, why aren't they going to a free clinic down the hall? This is just government solving a problem that government created. Your last point, and I will be brief about this one, about insurance, and this being no different than any other insurance. I have a right, I can have a car or not have a car. And if I'm forced to have insurance for my car, that is to protect you, sir, from me hitting your car, not to protect me. If I choose not to cover my car, that's my business. That's a completely different thing. That is protecting the public at large from any action that I might take, which is why laws exist. And I'll be quiet now.
All right, now, as far as the federal government, both the state and federal governments are subject to the Constitution. You know, there are constitutional limitations on what government can do. We vote for everybody. We vote for the House every 2 years. We vote for everybody. So if they're not doing what we want them to do, we can get rid of them. But the idea that the federal government should have, you know, that we should narrowly construe these laws, when who is it that can take care of a national problem? The states can't take care of a national problem. So to say we have to read the Constitution in the narrowest way so that the federal government can't take care of a problem that is really affecting our economy, that's not the way for our nation to advance. I mean, it's just, you know,
I gotta go,
whatever
the lawyers are here.
Now, in terms of the hospital, people come into a hospital. Do we want them to die?
Of course not.
So that unless we have some vehicle, federal government passed a law, if they're acute distress, those are the magic words, you must take care of them. Maybe the hospitals wouldn't want to do that, but they must do it. They must take care of it. Now, you say the federal government created the problem? I don't think that's a problem. I mean,
You don't think it's a problem?
that hospitals should be able to exclude people. We don't want you. You can't pay for it. I mean, that's not what a civilized society does. Now, having done that, granted, you got to pay for it. And so we've tried to devise a system where instead of making everybody pay for it by increasing taxes and everything else, we have a system that looks more even, and the young people who otherwise wouldn't buy the insurance are going to have to pay something for it, so it goes down for everybody. And that certainly makes some sense.
Now, let me go the other side.
I disagree that health care is a national problem. If I get hit by a car and I'm going over here to Winthrop Hospital, somebody in San Francisco is not burdened with that. So if New York State wants to take a particular position that we're going to treat people under certain circumstances, whether they have means to pay, whether we're not going to treat them at all, you're making a moral judgment on what should be. What should be. And I think that those are the precise types of judgments, such as the amount of welfare benefits, the duration of unemployment benefits that states traditionally make and should continue to make. To say that healthcare is a national problem is a stalking horse argument to back into a national healthcare system. It's a state problem. In the 70s, welfare benefits in New York were phenomenal compared to welfare benefits in Alabama, Georgia, Mississippi. And there was a tremendous influence of people either being thrown out of those states to come to New York or who voluntarily came to New York to get those benefits. Nobody argued that there should be a national level of welfare benefit for recipients. So I can suggest to you, that's the first part. The second part is, let's say the first part. It really goes too far. But it's a New York problem. The analogy to a driver's license is driving is a privilege. Okay, you would have to convince that there is a right to health care. You would say, well, it's terrible to leave a guy with an axe in his chest, but maybe the people of Alabama think that's just fine. And if the people of Alabama think that's just fine, why is it the moral imperative for the federal government and people in New York and Mississippi to say, we don't like that, and we're going to force this down your throat, and we're going to take away your choice, because right now, I'd go to any health insurer that I could afford. Okay? Or I could choose not to go to any health insurer. So when you say that you're encouraging choice by telling me I have now the option of buying any plan that's out there and don't have the option of not buying the plan, that's a limitation of my choice.
Look, the states have done nothing about health care. Massachusetts has done nothing.
So
that's a good idea to let people die? Is that a good
Let the
idea?
people of Massachusetts decide what their citizens want to do.
Well, I'm sorry, we have a national government that doesn't look at it that way, that doesn't allow Alabama to let people die.
They've been looking at it the wrong way.
Well, I'm sorry, I think that if we put that to a vote, should the people of Alabama, should we let them die because Alabama doesn't want to do anything? I don't think.
But that's not a legal argument.
Well,
That's a moral
I'm sorry.
argument you're making.
I am making a moral argument. And as far as the constitutional argument is
So we're
concerned.
going to legislate morality.
No, I'm legislating commerce, and the commerce is healthcare. I mean, the fact of the matter is, if this passes, all our insurance will go down. We will I'm sorry.
What planet are you from?
Our insurance will go down because more people, the young people that aren't paying now, the young people who aren't paying now will have to join, and that will reduce insurance premiums. The Congressional Budget Office has said that. No one has disputed this. I mean, we do.
It's a joke.
But the government, the attackers didn't
$1 billion
dispute that. The attackers didn't dispute that.
Debbie
Why don't
wanted
you
to-
ask her a question?
No,
Why
I
not?
She didn't want to respond though. She's
That's all right.
Debbie, go ahead.
Professor Friedman is so brave to come to this debate, so I'm thankful he's here. And he's made some great points. I just want to pick up a little bit about the question of, is health and welfare a federal versus a state issue? And I think we can look at the Constitution here. It says very clearly that state welfare should be the province of the states, not the federal
Where
government.
does it say that? I don't know. Where in the Constitution
Well,
does
it
say
does enumerate certain powers that are supposed to be exercised by the federal government, and unless they're enumerated, the federal government is not supposed to go there.
that? And there is a
And-
power,
and-
Tenth Amendment.
Congress shall have the power to regulate commerce among the several states. This is commerce.
And
What does
believe it
it
or
mean,
not,
several?
when that provision was being debated at the Constitutional Convention, there were delegates there, in particular George Mason of Virginia, who got up and said, we will not vote for the Commerce Clause power for this new government because we think that the Commerce Clause power, in conjunction with the Necessary and Proper Clause, will be used to force people to buy products.
And they lost. And they did put it into the Constitution.
Except, sir, they actually, the folks who voted for it said, your concerns are misplaced because the federal government's power is enumerated. There's no way it could possibly be construed as a power to require people to purchase products. That's actually what the delegates to the Constitutional Convention said. So there's no way they would have contemplated that the Commerce Clause could now be used to force Americans to purchase health insurance. And while there have been some judges who have said that health and welfare may be a concern of the federal government, I think that what they're really looking at is the health insurance market. Health care is quite different. It's an individual matter that should be regulated at the lowest level of government. It's the most intrusive sort of area of regulation. It concerns our bodies, the most private part of a human being. It should not be something that concerns the federal government. Health insurance is quite different from health care. And a lot of the arguments we're hearing in favor of this legislation go to, as Professor Friedman has said, the moral aspect of it. We want to leave a guy with an axe in his chest dying on the street. That goes to health care. That does not go to the question of who pays for it. And that has been lost in this debate. Congress has tried to conflate the two, and I think the court is looking at that. That's why they have serious doubts about this legislation.
Back in the corner.
For Professor Friedman, Debbie certainly could chime in. A lot of everything is based on, everything should be fair and everybody should share the cost with Obamacare. And here we go again, lower income is excluded. When does the free stuff stop? So it's not everybody is sharing the cost. You're excluding a certain sector of the population because of economic reasons. So how is everybody sharing?
Well, the people at the bottom are already covered by Medicaid, so they're not covered. And they're.
But how is that
The government, that's been here for 40 years. You want to get rid of Medicaid?
Yes.
You want the
Yes.
people at the very bottom to have no basis at all for covering their medical costs? I don't think so.
Doctor?
Yeah, hi. I think that maybe your statistics have to be evaluated. We've had Obamacare now for 2 years, and I've heard all the promises of what it was supposed to do, but I just want to remind you of several things, and then I'll ask you my question. The CBO said that this was going to cost us $850 billion for the first 10 years, and we got that figure by finding out that it didn't go into effect for 3 years. So really it's from year 4 to year 10. So really it's $850 billion for 7 of the 10 years. The second thing is when we read the bill, we found out that doctors' fees were not going to be included in the bill at all, so that's why we have doc fix and why we have to vote to pay that. So the only way we could keep it under $1 trillion was by excluding all that. But now, unfortunately, last month the CBO has reprogrammed it, refixed it, and now instead of $850 billion using the same program, it is double that. It's $1.78 trillion for 7 of the first 10 years without doc fix. So that was the first thing. The second thing, so your figures of that is going to affect and help us in healthcare is absolutely incorrect. The CBO has, and the Bureau of Labor Statistics have said that this year alone, in the second year of Obamacare, healthcare has gone up 12 to 15%. And if you can ask anybody in the room who pays for their own health insurance, everyone's health insurance has gone up. Except now, the question to you, the one statistic I would like you to, and both of you said that, the 40 million people who you're talking about, this is the whole point of your program, 40 million people. And you said incorrectly that this was, or correctly, I should say semantically, that this was not including illegal aliens. Yet. Of course it says it in the bill that it's not including illegal aliens, but the Democratic Party voted down a bill that would ask every emergency room, every doctor, in my office or anybody else's office to prove citizenship. So we really don't know how many of this 40 million people are in effect illegal aliens. But now the estimate from the Bureau of Labor Statistics says approximately 12 million people of that group are illegal aliens. And since you won't allow us to prove it in the hospital at Long Island Jewish or anyplace else, we really are treating illegal aliens in the program. The second thing is, the statistics now show that in that group we're talking about 12 million to 15 million people who make over $50,000 to $75,000 a year who just don't want to buy insurance. So we're really dealing with, and I don't say this I say this in maybe in an elitist way, but a wrong way, that there are only about 15 or 20 million people that don't have insurance, who are the working poor, who are not convicted of any crime, and who are living with families. And I personally feel we should give them free medical care, but not through the government. So my point is, the statistics now, when do we realize how much this is going to cost in every sort of way if you don't allow the statistics to be painted in front of us?
Well, the statistics are not a constitutional issue. We're arguing whether it's constitutional or not.
But you're arguing
But
morality.
the statistics or the amount of money that the government is paying. I mean, in theory, Obamacare will come in, and there are these various panels that's supposed to come in and present a more efficient way of handling things in the future. I mean, it hasn't come into effect yet. The mandate.
It's done with cost already without even.
Well, the mandate hasn't come into effect, so we don't know what's going to happen with these, with the various state procedures and these various alternatives that they're going to have. I mean, that's something that hasn't happened yet. So, I mean, all the government figures that I've seen about the number of people who are not subject to, who simply don't have it. I mean, and those numbers, are consistent from one analyst to another.
If I can just add, that, if you're done, Professor Friedman.
Yeah.
The question that's brought up by the two gentlemen, that goes to the heart of a lot of the concerns the 11th Circuit had. They said the exact same thing. They said, this is supposed to solve the problem of the 40 million uninsured, but the folks who are exempt from having to get the health insurance to begin with under the mandate comprise the 40 million, i.e. folks who have income under a certain level, illegal aliens, what have you. Okay, so it doesn't really solve the cost shifting problem. All it does is sort of keep it there, and really what it does is it tries to bring in a few people on the margins, particularly young people, to try to add to the insurance pool so that coverage can be expanded. So it really doesn't solve the problem, and the courts had a problem with the statistics because they said the statistics you're citing to us don't make any sense as congressional findings, and we're not required under the Constitution to pay unheeded deference to these findings. We're only supposed to pay deference, pay heed to rational findings. So what they've said is some of these findings are just not rational.
Well, I have Wikipedia here. Right here, and it says 49.9 million residents were uninsured. Wikipedia, right over
Yeah.
there.
She said-
And what's the source for Wikipedia? It was me last night.
Question right here.
Yeah, I just, my take is everyone makes these arguments, whatever. I look at it from a constitutionality. It's like when you apply a suspension in sport, you got to look at the letter of the law. And the constitutionality is forget these people are insured. It's like my mom always says to my father. It's a big giant game. They're all big games. It's always a big issue. It's insurance. It's this issue. I'm just looking from a constitutional point of view. If reading the Commerce Clause from the cases of Lopez and Morrison, you got to put a little bit of a curve on what the federal government can do. And in this case, I'm a 39-year-old. I used to have a car. I had to pay insurance. I had to go through Gaia. Guess what? Last year I don't have my car. Don't pay insurance. The point is, you can't just make a link. I'm 39. I've only been in the hospital once when I was young, when I was 10. I may live 5 years, I may 10 years. I may never go to a hospital. You can't just say you will definitely go to. I may not. I could live 10 years with healthy. I could go more vegetarian, work out, whatever. I could just become whatever, just whatever.
Hit by a bus tomorrow.
Then you could say, if you stretch it beyond the limit, so in other words, you're forcing me into commerce. Because if you can force me into commerce in the healthcare, you can force me into commerce in other areas. There's no limitations on it. So that's why the judges should look at it focused on that constitutional. Forget about, oh, this is a pending issue. This is healthcare. It's going to be another pending issue. Just in the same
You're
case.
doing a wonderful job, and I love what you're saying. But we have a lot of people.
Okay, in the
Do you have
same
a
case
question for
with
either one of our panelists?
expanding government power for violations of Fourth Amendment, yeah, it may be good for the time being. You got to look at going forward. I mean, that's my question.
All right, thank you. I don't hear the question. Go on.
No, my question was.
You agree, I think.
No, my question was, the flaw in the argument was that everyone's going to be involved in healthcare, so therefore it is interstate commerce. My question is how? Because you're kind of forcing. In other words, you're forcing me into interstate commerce with forcing me to buy the healthcare law, because by law I have to, unless I'm in that excluded group, which most
Everybody has to pay Social Security, right? Suppose they don't need it. Suppose they have enough money to pay. They still have to pay Social Security. Why? Because we want everyone to pay into the system so that everybody. That's what insurance is. That's what insurance is. And the people. Sorry.
Back here, right over. Question.
Professor, I think you have very good ideas. Your arguments are very good. However, you're missing the whole point. First of all, New York State has already established the exchanges. Now, who's going to pick out the exchange? What insurance companies are going to be set up that you can go to? Who's going to do that? The states.
Well, they're going to do it with the. Why are they doing it? Because the law requires them to do it. Without that law, they never did it before. It's only because the law required them to set up the exchanges that New York has done it.
You know what a lot of people say about the law? That there's, I don't want to,
Let's do a question, let's not argue with the
The
speakers.
effect of this is going to make competition less, because you're not going to be able to go choose your own insurance company. You're going to have to stick out one of these exchanges.
No, you can't. No, that's not true. You still pick out your own, but the exchanges are there. The exchanges are there for the people. Their regular insurance policies, companies just won't give them what they want. That's the whole point, to give you more choices.
Way in the back. Question, please.
For both panelists, how do you think the court will rule, and what do you predict the vote will be?
5-4.
Good question.
What a daring. You go. Let Debbie go first. Go ahead, Liz.
I actually thought when we started this process that we would lose in the Supreme Court because of all the precedents cited by Professor Friedman. But after the oral arguments, I feel that the court will strike down the individual mandate 5-4, and that they may actually the entire act.
Well, my prediction, Justice Kennedy, the very last thing that he said during the oral argument, if I can find the oral argument, which I had just a moment ago, he said maybe this is different. He said maybe, he had all of these arguments, and then he finally said maybe, I can't find it right now, but maybe this is, so I'm starting to think that maybe Kennedy's going to come around. That's my prediction.
Right here.
Okay, I had two objections to the arguments that you made earlier. I object to the specious argument that because states' rights have been used to defend fighting against civil rights, pro-slavery, that federal law is more noble or more holy. Federal law was used to justify the imprisonment of American citizens of Japanese descent. It isn't more noble, it isn't more holy. It's only a power that is wielded by moral or immoral people. And my second problem was, you pointed out the fact that, federal legislators aren't drawn into criminal prosecutions as often as state legislators. Is there anyone here who believes if they did what Charlie Rangel did, they wouldn't currently be in jail? Federal authority grants you a higher bar to cross before you're committed to criminal offense. So that is not a reasonable argument that state legislators are less moral.
Well, my point is a little different one. I mean, I'm a civil libertarian. I attack the federal government all the time. But the point is, why should there be a difference in the amount of legislative power that they have?
Because of the
Assuming
10th
they're both
Amendment.
that they both have the same level of morality. Why say to the states, you can do whatever you want, but you, the federal government, you have to, squeeze in some very narrow language.
Because of a little thing called the 10th Amendment.
The 10th Amendment does not say that. It says, well, the power is not delegated. Well, John Marshall, and the Supreme Court has given a very broad reading to the Commerce Clause, so therefore, the 10th Amendment is not involved in this at all.
Now, let's get a question. I know everybody has
It's a very bright law student. That's a good question.
Moderator, let's do it. Moderator.
So, your argument stands on McCulloch v. Maryland, but James Madison said that to interpret the Constitution, you need not look at the esoteric meetings they had in the Continental Congress and all that, but to the ratification conventions. That's when it was presented to the people. And Deborah, you talked about George Mason, the delegates. That's what was promised to the people, what the Constitution is. James Madison said you have to interpret it based on what was said during the ratification conventions. How many times did John Marshall, who was a delegate along with George Mason, the Virginia delegate to the ratification, how many times did he cite to the ratification conventions in his entire tenure at the Supreme Court?
I don't think he ever did.
He never did.
I don't think he ever did. Let me say something about that. I mean, are we originalists? Must you interpret the Constitution in terms of what the original founders decided? Now, during the Vietnam War, I was at the ACLU, we attacked the draft. The draft is unconstitutional. Why? Because Edmund Randolph said drafts stretch the strings of government too violently to be adopted. So I had a meeting with Scalia on something. I said, Justice Scalia, suppose I can prove to you without any doubt that the founders did not intend to give the federal government the right to draft. So he looked at me and he said, I'm an originalist, I'm not a nut. What does that mean?
Let me go back to this side, right here. Go ahead.
Okay, given the fact that healthcare is dispensed through the states, you have to buy everything through the states, it's totally intrastate, not interstate. How can the government even justify jurisdiction in this case?
Well, I mean, everything that listen, if you feed cows with wheat that you've already grown yourself and it never leaves the state, why is that interstate commerce?
It's not.
Because you aggregate everything. It's aggregate. You say if everybody in the same situation, can the government deal with the commercial result of everyone in the United States dealing with the same, with the same activity? And that's well established. I mean, they established. Booker v. Filburn was quoted by the Supreme Court in the Gonzalez case. You don't look at an isolated issue. You look at how everybody in the same situation, does it affect the commercial activity? Do people buy life insurance, health insurance in the United States? Is that a commercial activity? I think so.
Right back here.
In the beginning of this country, we left the old country because of government intrusion. And we didn't want our government to be lords and kings and queens. So we have a Congress, and they're acting, in my view, like the lords and the kings and the queens because they are exempt. They are one of the other groups that are exempt from this healthcare system. Why is it that what is good for the little people, us, is not included in Congress?
Vote them out. Vote for people who will change the law. That's our right. You don't like when Congress deals with its own health care? Vote them out. We have that ability. Why can't we do that?
Why is the law different?
They passed a law giving themselves very good health care. They've done that. We don't like that, we vote them out. That's the answer.
As a law student, is that just not based on law course? Very I believe that as far as precedent, there does seem to be more precedent for it. This is definitely interstate commerce culture. So given that, and given the expansive view of what Congress can regulate within the Congress clause, what would you say? You know that there's a couple of recent cases that started to, rein back the rating on that. And I think Professor Friedman brought up the point that those were issues that weren't necessarily interstate commerce purchasing. Whereas here in healthcare, this is definitely purchasing. And I think Friedman said that health insurance is interstate commerce. So how do you address that?
That's a great question. And Professor Friedman was right that the Violence Against Women's Act was not related to commerce, nor was the Gun-Free Zones Act. However, that was not the only reason the court struck down those two acts. The court did not strike it down merely because they were not commercial activity. The court also struck down those acts, again, because those statutes had not tied the activity to be regulated to interstate commerce. So that's the jurisdictional element argument. And also because they found that the findings were very attenuated and that the Congress was improperly using what Professor Friedman has referred to as the aggregate effect or substantial effects doctrine. They were using it too broadly. So the court said there is a limit on the Commerce Clause and we have to enforce it. And the way we're going to enforce it is we're going to require you to put a jurisdictional element in the statute, and we're going to require that your substantial effects are not so broad as to make the concept of enumerated powers utterly meaningless. Because, frankly, you can aggregate anything. Again, back to the broccoli. If you take an expansive view of aggregation and substantial effects, the government could force you to buy broccoli or a certain type of food.
But the Supreme Court has even said in other cases that held up that the aggregate view is okay, like Polly's Barbecue, when it was a private restaurant serving that didn't want to serve blacks, but it didn't really have a lot of interstate commerce, and yet the Supreme Court held that that was. How is it? I can't, I don't see constitutionally what the parameters are as far as how the Supreme Court is out. Both of you, how would you say that those parameters, what are they? Based on
Well, broccoli is not part of an integrated economic system. I mean, this was during the oral argument that kept saying that. It's not like, going to a hospital is an isolated act. Eating broccoli is an isolated act. Whereas going to a hospital and getting care, because even though you can't afford for it, it has an effect through the entire system. And therefore the government can regulate the entire system. I mean, that's a major difference there.
All right, now, okay, you want to?
Just one quick point on that. Yes, ma'am, let me just make one quick point just in response to Professor Friedman. I have to respectfully disagree with you on this, because existing in the U.S. and choosing not to buy health insurance is not part of any integrated system. You have a right to be an individual and exist without being forced to enter into a private contract with a health insurance company. So the question of where the line is to the young law student, It's a great question. That's why this is such a fascinating case and so important for our country. Because this case will define the limits of the federal government power under the Commerce Clause for a good generation to come, in my view. And we'll be interested to see how the court makes that distinction.
I'm going to say this, we're time for two more questions.
I have one.
And that statements. All right, way in the back.
This is a question, not a statement. Professor, you said that repeatedly that we have the power to vote people out if they're not doing what we want.
That's correct.
But that ignores, in the passage of this bill, the fact that people voted someone in for the express purpose of killing that bill, and that was Scott Brown. He was elected to be the 41st vote that would have killed the bill, and the Democrats subverted the process to get this bill passed before Brown ever had a chance to vote on it. So if we're going to essentially vote people out or vote people in order to do what we want, but Congress is just going to subvert it by using archaic rules of procedure,
Well,
how is that?
I'm going to object to your word subvert. I mean, 41.
He's one of your former students.
I'm sorry. I object to your use of the word.
He must have got an F.
No, but I mean, this whole, let's not get into the whole, Senate, the way the Senate operates. But the point is, the law passed. We don't like it. We've got another chance. You have another chance. To vote in enough people who will overturn the law. I mean, that's the way the system works.
2012 is all about.
This is a question.
Question.
Last question.
Professor Epstein said
We're going to be, everybody's hands were up, okay?
Last question.
My decision.
Sorry, he's the judge. He's going to hold you to contempt.
Professor Epstein has said that Wickerburg versus Filburn has been a total disaster, and it may be that this case is the one that illustrates what a disaster and how stretched Wickard v. Filburn made the Commerce Clause. What are the chances that the Supreme Court will overturn it?
Good last question.
Yeah, that's a very interesting question. Actually, Senator Rand Paul submitted an amicus brief, and he made that very point, and he asked the court to overturn Wickard. I don't think the court would overturn Wickard. It's been in existence for so many decades, and it's the cornerstone of so many significant acts
Policies.
and policies. It would be extraordinary. I really think the court can deal with this case on far narrower grounds. I think they just got to look at Lopez and Morrison, and they can strike it down.
All right, I want you to come to my next ACLU meeting.
With all the other comments.